An 8-hour phone call between the White House and a local special prosecutor on the exact day a special counsel is appointed isn't a coincidence. It is a material coordination event that has left a gaping hole in the integrity ledger of Fulton County.
It's going to be a lawsuit. That's number one. It's going to be a lawsuit on many grounds because there's no reason to actually treat these people differently, and that's the key. So you can take the passion out of it. Take the fact that there are 5 African-American women, take the fact that it does seem maybe racially motivated, the fact that Democrats are now winning your DA's races. Here's the issue that you have, and it's within the bill itself.
Now, Fulton County DA Fani Willis responded to today's vote in a written statement saying, quote, "This bill is nothing more than a continuation of Burt Jones's political attack on me and my Metro Atlanta colleagues. He is doing this on behalf of Donald Trump and his fellow MAGA extremists in the Georgia Senate who fear being held accountable to the law like every other person. The targeting of 5 African-American women Democrats who were chosen by the voters of their counties to serve as DAs is racist, sexist, and clearly unconstitutional." Now, this bill heads over to the House for further consideration. At the state capitol, Deidre Dukes, Fox 5 News.
While the district attorney claims she cannot recall the details of this meeting, the forensic audit of her office's communications is revealing a complex web of jurisdictional commingling that threatens to liquidate her entire RICO case. We are documenting a scenario where the internal controls of a local prosecutor have been bypassed by national political interests, creating a systemic conflict of interest that the Georgia State Senate is now moving to correct through a forced reclassification of the ballot itself. The trust equity of the Fulton County DA's office has entered a state of involuntary liquidation, and the results of this audit will determine if the rule of law can survive a total management collapse.
Indicted President Trump and the 18 others. Everybody's like, what do we do? What do we do? And kind of the prevailing wisdom down here is, well, just let it work its way through the court system. I'm like, that's not good enough for me.
What?
That's not good enough for me. So I began to work with our lawyers down here and just kind of investigate what could be done. And the Georgia Constitution actually gives the same authority to investigate the affairs of the state to the legislature as it does the Attorney General.
Oh, wow.
And our Attorney General was not doing anything. And so I wrote a resolution that said we're going to form a committee. We're going to give it subpoena power. We're going to give it the ability to swear witnesses in under oath, which at our state level is not something that we ever do. And we did. And we fought Fani Willis in court for a year and a half, finally got her to come appear. She appeared on December 17th of last year. And what we discovered in that hearing was shocking. We discovered the coordination with the Jan 6 committee. We discovered the coordination with the White House, but she, of course, doesn't remember anything. And Nathan Wade, who was her paramour, who was conducting all of the work for her, in his congressional testimony, he also said, yeah, I know I billed for conversations with the Jan 6 committee, but I don't remember who I met with or on the 8-hour meeting. I have no idea who was there, and I don't know what we talked about. I know the same day that Jack Smith was appointed by the White House that I was on a phone call with the White House for 8 hours. But I have no idea who I was on the phone with, and I don't know what we talked about. That's the same day, by the way, that Michael Colangelo left as the number 3 guy at DOJ.
That's right. And went down there.
And went to New York to help Alvin Bragg. So
that was the piece for me that really was like, oh, this is all coordinated.
Yeah, because who's leaving as the number 3 guy at DOJ to go work in the city DA's office?
I am Camilo Motado, and this is Camilo's House. As a certified public accountant focused on forensic data verification, I look past the political theater to see the underlying statement of operational loss. In a standard financial audit, if a firm claims it cannot remember a major 8-hour transaction involving its most senior partners, you immediately issue a disclaimer of opinion and flag the account for potential fraud. Today, we are performing a jurisdictional commingling audit on Fani Willis and the Fulton County DA's office. We are documenting the testimony of State Senator Greg Dolezal, who has successfully audited the audit trail between Willis, the January 6th committee, and the Biden administration. We are analyzing a scenario where the independence of the prosecutor has been replaced by a consolidated prosecution ledger, and the Georgia legislature is responding with a hostile brand liquidation designed to strip the partisan ticker symbols from the Metro Atlanta ballot. The forensic breakthrough, in this case, came on December 17th, when Fani Willis was finally forced to appear before the Georgia State Senate's Investigative Committee. In any professional environment, the duty of disclosure is absolute, Yet Willis and her former special prosecutor, Nathan Wade, have suffered from a sudden and systemic amortization of memory. Wade, who was the lead auditor for the Trump RICO case, admitted in his testimony that he billed for conversations with the January 6th committee, but claimed he had no idea who he met with or what was discussed during an 8-hour meeting. From an investigative standpoint, an 8-hour meeting is a material event. It is a full business day of high-level coordination. In accounting terms, claiming you don't remember the counterparty to an 8-hour transaction is a reporting failure that suggests an intentional scrubbing of the ledger. The audit trail gets even more complex when we look at the human capital transfers occurring between the Department of Justice and local DA offices. On the same day that Nathan Wade was on a marathon phone call with the White House, Jack Smith was appointed as special counsel and Michael Colangelo, the number 3 official at the DOJ, left his high-ranking federal post to join Alvin Bragg's office in New York. As a CPA, I track resource allocation patterns. Why does a top-tier federal executive take a demotion to work for a local city DA? It is a strategic asset deployment. This is not independent law enforcement. It is a consolidated management strategy where the parent company, the DOJ, is embedding its auditors into the subsidiaries, the local DAs, to ensure a synchronized liquidation of their political target. This commingling of assets creates a material conflict of interest that renders the entire prosecution reputationally insolvent. While Judicial Watch continues its forensic recovery action to obtain 212 documents that Willis has been hiding from the ledger, the Georgia State Senate has decided to perform a systemic reset of the political market. They have passed House Bill 369, a measure that would delist the party affiliations of local offices in the Big 5 metro counties: Clayton, Cobb, DeKalb, Fulton, and Gwinnett. From a market analysis perspective, this is a hostile brand liquidation. These 5 counties are the high-yield Democratic assets of the state. By removing the Democratic ticker symbol from the ballot for DAs, school boards, and tax commissioners, the state is performing an information redaction designed to increase the due diligence cost for the average voter. Senator John Albers, the bill's sponsor, argues that this is a risk mitigation strategy for public safety. He claims that taking politics out of the equation ensures that DAs focus on their duties rather than their base. From an investigative standpoint, this is a claim of operational neutrality. However, the scope of the audit is highly selective. If partisanship is a liability for public safety, then why is this standard operating procedure not being applied to all 159 counties? Why is the sheriff's account allowed to remain partisan? By targeting only the Big 5 diverse, Democratic-leaning counties, the legislature has created a material inconsistency in the application of the law. It is a special legislation that targets a specific demographic segment of the market, which is why critics like Senator Harold Jones are flagging it as unconstitutional and racially motivated. Fani Willis has responded to this delisting with a disclosure of bias, calling the bill a racist and sexist attack. She argues that the targeting of 5 African-American women is a management override intended to undermine the will of the voters. From a fiduciary perspective, Willis is claiming that the state is attempting to liquidate her mandate because they fear the outcome of her audit. But as a forensic accountant, I have to look at her own liability balance sheet. Her office is currently facing a $17 million risk. The potential legal fees and reimbursements her office may be forced to pay to the Trump RICO defendants if the case is found to be improper or cheeky, as the critics say. This is a contingent liability that could bankrupt the Fulton County Prosecution Fund. The Judicial Watch litigation is the final stress test for Willis's internal controls. If the court rules that she must release those 212 documents, we will finally have the source documents for the coordination with the January 6th committee. In professional auditing, documentation is the only defense against allegations of collusion. If those documents show that the Fulton County ledger was actually being managed by Washington, D.C. auditors, then the independence of the district attorney is a material misstatement. The Trump RICO case didn't just fall apart because of a personal relationship. It fell apart because the integrity of the data was compromised by a lack of procedural transparency. We have to audit the social cost of this nonpartisan reclassification. By removing Democratic and Republican from the ballot, the state is creating an information asymmetry. In any market, when you remove the brand name, the consumers, the voters, are more likely to make a selection error. This strategic ambiguity favors the incumbent management in some cases, but in the Big Five counties, it is designed to dilute the power of the majority shareholders. It is a tactical cloaking device that allows the state to audit the voters rather than letting the voters audit the DAs. This information redaction is a systemic risk to the transparency of the election ledger. The internal conflict within the Georgia Republican Party is also a factor. Senator Dolan mentioned that the prevailing wisdom was to let the court system handle Willis, but he decided that wasn't good enough. He leveraged the authority of the Georgia Constitution to form an investigative committee with subpoena power, a regulatory upgrade that has finally forced the disclosure of the coordination with the White House. This is a regulatory oversight war. The legislature is auditing the executive branch, the DA, because they believe the Attorney General, the official auditor, was not doing anything. It is a systemic failure in the chain of command that has resulted in a multi-front forensic investigation into a single county official. As we reconcile the data from March 2026, the Fani Willis asset is in a state of permanent impairment. Whether it's the 8-hour phone call, the 212 hidden documents, or the hostile takeover of her ballot label, she is facing a liquidity crisis of trust. Her defense that she doesn't remember is an insolvent narrative in a world of digital footprints and billed hours. The coordination with the White House is a material fact that proves the RICO case was not a local prosecution, but a national policy implementation. The Georgia State Senate is now performing the final liquidation of her political standing, and the voters of Georgia are the external auditors who will have to determine if the rule of law can be restored after such a systemic breach. My forensic verdict is that Fani Willis has defaulted on her fiduciary duty to remain an independent officer of the court. The commingling of jurisdictional assets with the January 6th committee is a breach of ethics that has contaminated the prosecution ledger. The nonpartisan bill is a draconian market correction by the legislature, a special law that targets her brand because her operational performance has become a national liability. We are looking at a management team in Fulton County that has liquidated its credibility for a political payday that may never come due. I want to hear from you. Is the nonpartisan ballot a legitimate correction of political bias, or is it a tactical strike against Black Democratic women as well as claims? Does an 8-hour phone call with the White House prove collusion, or is it just routine interagency communication? Let me know in the comments. Your perspective is the only audit that matters when the integrity of the DA and the privacy of the ballot are sitting on the negotiation table. I am Camilo Motado, and this is Camilo's House. Subscribe to stay informed on the numbers, the laws, and the truth behind the headlines. Stay safe.